Let the record reflect, State's President, Defense Counsel, and the defendant are all present.
Good morning, Your Honor.
Good morning.
Sarah Miller and Andreas Gardner on behalf of the state.
Kevin Shirley, Mr. Hollander, and Ms. Perez on behalf of Mr. Wilson.
All right, Mr. Perez, if you'll put your full name on the record for us.
Gwendolyn Perez.
Thank you. And the defendant is present. We're ready to proceed this morning.
Judge, we do just have a few issues we want to put on the record. Mr. Shirley and I spoke. We have all three of our experts sitting in the courtroom. The state has Dr. Michael Herkov over here. The defense has Dr. Hyman Eisenstein and Dr. Mark Mills. When we go through the diagnoses and the records, all of the medical records regarding mental health are from the jail. They cannot be characterized any other way. Defense has agreed with that. So the issue is we've asked the experts to just refer to them generally as jail records or incarcerative records so that there's no mention of what he was in jail for or why. But I just want to put that on the record. That's what we've agreed to. The experts understand that. They're not going to go into great detail about why he was there, but the records are critical in this part of the proceeding.
Okay. Mr. Shirley?
She's absolutely correct.
Okay. So no objection, and you stipulate to that?
Yes, sir.
And Mr. Wilson, you're aware of that as well, and you're okay with that? Okay.
And Your Honor, the other, there is a letter that the defendant's sister wrote. It's not admissible given that it's hearsay. However, she was not flown in for this part of the proceedings, so the state is not going to object through that being admitted through their experts. So I want to put that on the record as well.
So the state stipulates to admission of that?
Yes, Your Honor.
Yeah, in addition, under 921-141-1, hearsay can be admissible in the penalty phase. So, but we appreciate the state's stipulation.
All right. If the state's stipulating to it, then that's fine.
Your Honor, there is also a proffer Mr. Shirley discussed with me this morning regarding some photos. So I don't know if we want to do that after the state rests in the penalty phase or if we want to do that now.
I would rather do it as we get ready to close our case.
Okay.
If I may.
Explain a little bit more about what you're talking about.
Yeah, I've got some photographs of Mr. Wilson in both individually and in a family context as he grew up. We don't have anybody here that was present when the photographs were taken that can say that they're fair and accurate depictions, with the exception of Mr. Wilson himself.
Okay.
Mr. Wilson has the absolute right not to testify. I'm going to proffer them. Mr. Wilson's going to invoke his right. I want them part of the record, but just proffered so that they're part of the file in case post-conviction proceedings come down the pipe. You understand?
I do.
Okay.
All right.
But I don't want to do that right now.
That's fine.
I'd rather just do it at the time that you inquire of Mr. Wilson as to whether or not he's going to testify.
Right.
Okay.
All right. And just, I guess, while we're on that subject, Mr. Wilson, as I stated before during the earlier phase, you have the right to testify or not testify. It's your decision. No one can make you testify if you don't want to. No one can tell you to testify if you don't want to. So it's only your decision. And no one can tell you, and no one can prevent you from testifying if you want to. That's what I meant to say. So just bear that in mind. We'll have that conversation at a later point. Does the state have a copy of the preliminary instructions that were agreed to? And I guess, have they been agreed to first, the preliminary instructions?
Those were the ones that the court provided us last time that we were before the court.
Okay.
The state did not have an objection to what the court had presented to the state. I can print out an additional copy if the court would like.
Yes.
Very well.
And we didn't have any objection either.
Okay.
Yes.
And I know I asked before, but I'll ask again. You want me to read that portion of the instruction related to the defendant's right to remain silent?
Yes, please.
All right. Any objections to the preliminary instructions, this draft that's been presented to the court as promulgated by the state? Any objections from the defense?
No, that's fine, Judge. Thank you.
All right, very well. And then, so we'll bring the jurors out. We've got the alternates back. Everybody has their notebooks back on their seats. Anything else we need to address prior to bringing the jurors out?
No, Your Honor.
Okay. Let's bring them out.
Jurors entering.
All right, please be seated. Ladies and gentlemen of the jury, welcome back. By a show of hands, was anyone on the jury unable to follow the court's previous instructions about doing any research, looking up anything, or discussing anything about their service as a juror on this case? Seeing no hands, we're ready to proceed. Members of the jury, you have found the defendant guilty of 2 counts of first-degree murder. The only issue before you in this phase of the trial is to determine the appropriate penalty. The penalty for each of these crimes is either life in prison without the possibility of parole or the death penalty. Before proceeding further, it will be helpful if you understand how this proceeding will be conducted. The attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the penalty phase of this trial. What the lawyers say during opening statements is not evidence, and you are not to consider it as such. After the attorneys have had the opportunity to present their opening statements, the state and the defendant may present evidence. The witnesses may be called to testify under oath. If so, they will be examined and may be cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. This evidence, along with the evidence that you heard during the guilt phase of this trial, is presented for you to determine whether the state proved beyond a reasonable doubt the existence of the alleged aggravating factors. If so, you must weigh whether the proven aggravating factors are sufficient and whether the aggravating factors outweigh any mitigating circumstances the defendant proves by the greater weight of the evidence. Finally, you will decide whether the defendant should be sentenced to life in prison without the possibility of parole or to death. At the conclusion of the evidence and after the argument of counsel, you will be instructed on the law that will guide your deliberations. An aggravating factor is the only circumstance recognized by Florida law that could result in a defendant receiving the death penalty. An aggravating factor increases the gravity of a crime or the harm to a victim beyond the harm inherent in every first-degree murder. You must unanimously agree that an aggravating factor was proven beyond a reasonable doubt before it may be considered by you in arriving at your sentencing decision. The aggravating factors alleged by the state in this case are: 1. Wade Wilson was previously convicted of a felony and was under sentence of imprisonment or on community control or on felony probation at the time he committed the first-degree murder in this case. 2. Wade Wilson was previously or contemporaneously convicted of another capital felony or a felony involving the use or threat of violence to another person. 3. The first-degree murder was especially heinous, atrocious, or cruel. Heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to, or even enjoyment of, the suffering of others. The kind of crime intended to be included as especially heinous, atrocious, or cruel is one accompanied by additional acts that show that the crime was consciously or pitiless and was unnecessarily torturous to Christine Melton or Diane Ruiz. 4. The first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, in order for this aggravating factor to apply, a heightened level of premeditation, demonstrated by a substantial period of reflection, is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. Once the state has presented evidence of the existence of aggravating factors, victim impact evidence may be presented. Such evidence is only presented to demonstrate the victim's uniqueness as an individual and the loss to the community by the victim's death. However, victim impact evidence must not be considered by you as an aggravating factor. Mitigating circumstances. A mitigating circumstance can be anything that might indicate the death penalty is not appropriate for the defendant. It is not limited to the facts surrounding the crime. In other words, a mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that may indicate the death penalty is not an appropriate sentence in this case. Whether a mitigating circumstance has been proven is an individual judgment by each juror. A mitigating circumstance need not be proven beyond a reasonable doubt, but must be proven by the greater weight of the evidence. After the evidence has been presented, the attorneys will have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will instruct you on the law. After the final instructions are given, the alternate jurors will be released and you will begin your deliberations. You should not form any definite or fixed opinion until you have heard all the evidence, the argument of the lawyers, and my instructions on the law. Until that time, you should not discuss the case among yourselves. Your decision must be based solely on the evidence or lack of evidence and the law. During the penalty phase, the court may take recesses, and you would be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about this case, tell him or her that you are on the jury and ask that person to stop. If he or she persists, leave that person at once and immediately report the matter to the bailiff, who will advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you're in the courtroom. Turned off means that the phone or other electronic device is actually off and not in a silent or vibrating mode. You may not use these devices during recesses, but even then, you may not use your cell phone or electronic device to find out any information about the case or communicate with anyone about the case or the people involved in the case. Do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess, please double-check to make sure your cell phone or electronic device is turned off. At the end of the case, while you are deliberating, you must not communicate with anyone outside the jury room. You cannot have in the jury room any cell phones, computers, or other electronic devices. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay. A contact phone number will be provided to you. The penalty phase must be tried by you only on the evidence presented in your presence and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation of their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned or use the internet to look at maps or pictures to see any place discussed during the penalty phase. Jurors must not have discussions of any sort with friends or family members about the case or the people and places involved. Do not let even the closest family members make comments to you or ask questions about the penalty phase. In this age of electronic communication, I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. What are the reasons for these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, I have no way to make sure that the information you obtain is proper for the case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you find. That is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity that our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions such as serving time in jail, paying a fine, or both. In every criminal proceeding, a defendant has the absolute right to remain silent. From the exercise of the defendant's right to remain silent, a jury is not permitted to draw any inference regarding the existence of an aggravating factor or an appropriate sentence, and the fact that a defendant did not take the witness stand must not influence your sentencing decision in any manner whatsoever. The attorneys are trained in the rules of evidence and the trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had the witness been permitted to answer. It may be necessary to confer with the attorneys out of your hearing to discuss the matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will last. When such conferences occur, they will be conducted to consume as little of your time as is necessary. Counsel approach. Ready to proceed.
Yes, Your Honor.
And Ms. Shirley, is defense ready to proceed?
Yes, sir, thank you.
All right.
Good morning. A little bit over a week ago, when we first met, the defendant was unknown to you, and he was presumed by every one of you to be innocent. That's now changed, because collectively, unanimously, you all have heard the horrific, graphic facts of this particular case and determined him to be guilty of each of the charges with which we've charged. The phase of this trial is penalty. The state of Florida is asking you to sentence the defendant to the ultimate penalty, and that's death. Not all murders are first-degree murders, ladies and gentlemen. Not all first-degree murders warrant the death penalty. It's only those murders that the state proves beyond an exclusion, and to the exclusion of every reasonable doubt, whereby a first-degree murder is aggravated, that death is warranted. Now, a little bit over a week ago, the burden was on the state to prove the first-degree murders beyond a reasonable doubt. And this week, it's our burden to prove the aggravation of those first-degree murders beyond a reasonable doubt. In this phase, we're going to focus on what makes this first-degree murder aggravated. Now, as the court instructed you, before there is a sentence of death, you must unanimously agree that at least one aggravator, just one, has been proven beyond a reasonable doubt. We are submitting to you four aggravators. 4 aggravators for one of the first-degree murders, and 4 aggravators for the second first-degree murder. Ladies and gentlemen, 3 of which, on each, you've already decided. It was inherent in your verdict. 3 of which have already been proven. 1 you're going to hear about shortly here today. The first 2 I want to talk to you a little bit about. One is called cold, calculated, and premeditated. The second one is referred to as heinous, atrocious, and cruel. Now, these might be aggravators that you may have heard about over the course of your life, but I want to go through them with you. The first one is called cold, calculated, and premeditated. Now, what this factor forces you to do is it forces you to essentially consider what his plans were and what his intent was at the time of the killing. Okay? The aggravator forces you to consider what he went through for the killing. Okay? And the evidence that we've presented to you during the course of the trial already proves this factor. It involved three things, ladies and gentlemen. And I would submit to you, he selected, he secluded, and then he strangled. That's what he went through to establish cold, calculated, and premeditated. Remember what he said. He was a lion. They were his prey. He could sense it. It just took him 2 minutes. They wouldn't scream. They wouldn't yell. He wouldn't get hurt. He wouldn't get scratched. They couldn't get away. Even if they wanted to, he was too strong. Those were the people that he went after. On the 7th of October of 2019, he went after Christine Melton. It started at the Buddha, right? He calmly befriends her. He goes up to Miss Johnson, who's your friend. He introduces himself as JR. He doesn't introduce himself as Wade Wilson. No. He introduces him as JR. He gives a fake name. He calmly befriends them. He's selected Miss Melton. That's who he was going after. He gains her trust. They go outside. He could have gone home with Miss Montanez. No. He chooses to go with Miss Melton. Where? To Mr. Shepard's. Where they become intimately involved. Where they subsequently leave and they go back to Miss Melton's apartment. And what does he do there? He waits. He waits for Miss Johnson to check with Miss Melton. Are you okay? You good? Yeah. Good. Why? Because Miss Melton has put her trust in this person. She's been intimately involved with this person. He's waiting. He has selected her. Miss Johnson leaves. There's no cause for concern, and no triggers, no red flags. Why? Because he's charming, right? 9 times out of 10, it works. It's worked here. Now, he's got Miss Melton all to himself. He's managed to seclude her like a lion with his prey.
Can I have counsel approved for just a second, please?
once again, the evidence during the course of our guilt phase showed you. He waited. What did he tell his father? He waited for her to fall asleep. And then what wound up happening? Well, he waited because he told detectives he doesn't get scratched, doesn't get hurt, quiet, they don't yell, they don't get away. He's too strong. What does he do then? He goes ahead and inflicts blunt force trauma upon Miss Christine Melton. And then he goes ahead and places his hands around her throat, applies pressure until she is dead. Remember the broken nails? Ladies and gentlemen, the long, drawn-out nature and circumstances surrounding Miss Christine Melton's death is cold, calculated, and premeditated. He selected her, he secluded her, he strangled her. Cold, calculated, premeditated also applies to Miss Diane Ruiz. Remember what he told detectives. I've already done it. I'm going to do it again. That's what was going through his head. Cold, calculated, premeditated. Hours later, that same day, he's in Miss Melton's car. He comes across Miss Ruiz. He tells detectives the way he approaches her is he asks her, "Where is the school?" He calmly befriends her, manages to get her in the car. What does he say? He says, "We drove to the school?" I was going to drop her off, but in my mind, I knew that I wasn't. And as soon as she was going to get out, I grabbed her by the neck and choked her. She came back to life 3 or 4 times. He didn't do that until he secluded her, ladies and gentlemen. He selected her, secluded, and then strangled. Not once, not twice, not 3 times, but according to him, she came back to life 4 times. And he told you he was not going to let her go. He told detectives, I was going to drop her off, but I knew in my mind I wasn't going to. That's cold, that's calculated, that's premeditated. Heinous, atrocious, and cruel. The law says it is one that is accompanied by additional acts that show the crime was conscienceless, pitiless, and was unnecessarily torturous to Christine Melton nor Diane Ruiz. It focuses on the means and manner in which the death is inflicted and the immediate circumstances surrounding the death. Ladies and gentlemen, the reason why we submitted those photographs of those injuries, okay, in addition to the medical examiner's testimony, is because those pictures demonstrate what words can't do justice to in terms of heinousness, atrocity, and the cruelty of these murders. Both Christine Melton and Diane Ruiz endured a high degree of pain, utter indifference. It was outrageously wicked, vile, and shockingly evil, according to the jury instructions. With regards to Christine Melton, what did you learn? She had a large number of bruises around her body and on her face. She had swollen eyes. She had contusions. She had bruising all over her torso and her arms. She had hemorrhaging on her neck. She had scalp bruising all over. When they removed it, all over. Dr. Coyne described that the blunt force trauma that was inflicted upon Miss Melton was so significant that the force that was directed towards the outside of Miss Melton went to the inside. Okay? All the forces went inward to her body. And what did you hear? You heard about contusions to her lungs. You heard about her liver. You heard about her bladder. You heard about her colon. You heard about her brain swelling, ladies and gentlemen. Remember the brain swelling? The doctor specifically said that didn't happen after the strangulation. That happened before. And that's all prior to the strangulation itself. That's before he puts his hands around her throat, applies pressure to the point where her life leaves her body. High degree of pain with utter indifference. Beat her, strangled her. He didn't care whether she lived or died. That is utter indifference. We get to Diane Ruiz, right? What do we know from her? Fracture of the nasal bone. Bruising on both sides of her body. We know about bruising to the back of her forearm, the back of her left hand, the broken finger. We know about, contusions on her upper back. We know about the hyoid bone broken. We know about the tracheal cartilage also being injured. We know about the multiple rib fractures, not only in the front, but also in the back, from significant compression. And then we learn about the hemorrhage to the back of her neck, right? Ladies and gentlemen, we learned that the struggle was so intense that Dr. Coyne said, when we looked at the autopsies of both women from the internal and the external examination, he learned, and now you, that their struggle for the last moments of their life was intense. And we know that he showed utter indifference. So, ladies and gentlemen, we are not going to be putting on evidence today with regards to cold, calculated, and premeditated. We will not be presenting you with any further evidence of any heinous, atrocious, and cruel, because quite candidly, the evidence is already before you and is in a matter of the record. Now, the court is also going to give you an instruction that says you're going to hear about the defendant was previously or contemporaneously convicted of another capital felony or a felony involving the use or threat of violence to the person. Ladies and gentlemen, this too is inherent in your verdict. and has been proven by the evidence because of the contemporaneous convictions for first-degree murder involving both Miss Diana Ruiz and Miss Christine Melton. When you found for one, you also found for the other and vice versa. Let me explain. He was contemporaneously convicted of a capital felony. Capital felony is first-degree murder. You found him guilty of first-degree murder, not once, but twice. Met that portion of it. Or it's a felony involving the use or threat of violence to the person. First-degree murder, ladies and gentlemen, is a felony involving the use of violence, the threat of violence to the person. So as you can see, you've already found that as well. The one you're going to hear about today is that the capital felony was committed while a person previously convicted of a felony or under a sentence of imprisonment or on community control or on felony probation. You're going to learn that the defendant was on probation for a felony out of Palm Beach. He was sentenced on September 18th, 2019, just 2.5 weeks prior to these murders. Lastly, ladies and gentlemen, you're going to hear victim impact. You're going to hear that it's not evidence of aggravating factors. Okay? What it does show is it does show the uniqueness of Miss Melton and Miss Ruiz and the resultant loss that their death caused the community. Now, the judge is going to instruct you in this trial about the process that you'll have to undergo. Okay? And the process you have to undergo to determine your sentence is that there's no mathematical equation, ladies and gentlemen. Okay? That you have to understand. It's just a weighing process. It's where you get to determine the weight, the substance of the aggravation, and you get to compare it with the mitigation. That's it. And during the course of this case, you may have been thinking, you know what, I'd like to know a little bit more about Mr. Wilson. And what we expect you'll hear is that you'll hear from some doctors, and we expect that the defense will put on and tell you that the defendant has some mental health issues, and we expect that they'll blame some of his history, and they'll be offering this to you. We expect as mitigation for the murders of Miss Christine Melton and Miss Diana Ruiz. Now, the law that you will hear and that you heard during jury selection and that you're going to hear again after, you're going to be instructed that this doesn't compel you, okay, or require you to determine that the defendant be sentenced to death. It does neither of those things, okay? The question before you, ladies and gentlemen, is whether the aggravation, once fully proven, is whether it's sufficient to warrant the death penalty. And ladies and gentlemen, on behalf of the state of Florida, I submit to you, it is. Thank you for your time.
Sure.
Thank Morning. I haven't had an opportunity to talk to you since jury selection, so I've looked forward to this. I'm sorry, Judge. I'll take it up with him when I get back to Charlotte County. Thank you. This is an opening statement. I want to caution you on one thing. Anything that the state says, anything that I say in either opening or closing isn't evidence. We're going to have remarks to you. We're going to have a lot more remarks to you in closing argument, because that's what it is. It's argument. But please, we're not trying to deceive you or mislead you or anything. We're sitting here listening to the witnesses. We're taking notes. And you know, maybe we heard it different than what you heard it. There are some remarks that Mr. Gardner just made to you with regard to evidence that came to your attention. I dispute some of those, but we're going to argue those later in this particular proceeding. You use your recollection. You've been taking notes. You get to take notes again during this part of the proceeding. You get to rely on other jurors' recollection of the facts and circumstances as they were presented to you that resulted in the conviction of Mr. Wilson, and you rely on those. Don't rely on the state or I to be 100% factually accurate in all of our representations to you. On behalf of myself, Mr. Hollander, Ms. Perez, more particularly Mr. Wilson, we want to extend our appreciation. What we're going to be asking of you is probably going to be one of the most difficult decisions you'll ever have to make during your lifetime. We know that. We appreciate it. You might be a little bit, confused wouldn't be the right word, because as you sit here, you know there's only two possible penalties. One is life in prison, which means Mr. Wilson would go to prison for the rest of his life. Mr. Wilson will die in prison, or the death penalty, in which case Mr. Wilson will die in prison. The state has told you that they're going to primarily rely on evidence that's already come to your attention. Well, we're going to do that too when we're arguing against the aggravating factors. I'll tell you, right from the start, the state has one aggravating factor. I'm not going to argue against it. The fact that there were two homicides that were committed contemporaneously, that's one of their aggravating factors. To argue against that would be ludicrous, and I wouldn't want to try and mislead you. The other one is the fact that Mr. Wilson was on probation at the time that this offense was committed. The beauty of this particular law is that you get to determine what weight you're going to give to these aggravating factors versus the mitigating circumstances. Obviously, we dispute the cold, calculated, and premeditated. The judge has already read the instruction to you. I'm not going to read the instruction in its entirety because this isn't that part of the trial. But please keep in mind as you're contemplating these things that it requires a heightened level of premeditation demonstrated by a substantial period of reflection. This isn't just a spur-of-the-moment type of thing. Oh, something pops into somebody's head and they act upon it. It requires a substantial premeditation. We'll get into the argument on that later, and I'll be able to show you examples from the record. The other is with regard to heinous, atrocious, and cruel. That isn't the jury instruction. The jury instruction is especially heinous, atrocious, and cruel. And the judge has already given you instructions on what heinous, atrocious, and cruel means and given you examples in the instruction. But the judge doesn't give you and is not going to give you an instruction on especially what makes this particular offense worthy of even your consideration of the death penalty. Why is this that one case that stands out? And you're going to have to make that decision, and that's the big decision with regard to that aggravating factor. Now, you're going to hear some mitigating circumstances, and we've already talked about this. We talked about it in jury selection. The reason they're called circumstances and not factors is because they don't have to be proven beyond every reasonable doubt. They only have to be proven to you by a greater weight of the evidence, a little bit more than not, as we talked about in jury selection. Among the mitigating circumstances, Mr. Gardner even alluded to it. You can take all kinds of things in Mr. Wilson's life and treat them as mitigating circumstance. The few things that you've heard about him from the record seem horrendous. But if you go back and you recall the testimony of witnesses, and this evidence has already been shown to you, when the witnesses were questioned about what Mr. Wilson was like when he's not on drugs, he's charming, he's polite, he's cool. I didn't know they still use that phrase. He's in a good mood, he's friendly, he's outgoing. These are all mitigating circumstances that you can take into consideration when you're weighing them against aggravating factors. The other type of mitigating circumstance that you can use is mental illness. Now, we have two doctors that are going to testify before you here shortly. Dr. Hyman Eisenstein, who's seated over there, he is a neuropsychologist. He will tell you what a neuropsychologist is. He'll tell you what his education is. He'll tell you what his experience is. He'll tell you why he is a person that can make judgment decisions and give you his opinion as to somebody's mental status. He will tell you that he met Wade Wilson, went and sat with him on a couple of different occasions. He'll tell you the batteries of tests that he had Mr. Wilson perform. He'll tell you, well, he'll describe what the tests are and what they're designed to do. He'll tell you how Mr. Wilson did on each of these tests, and then he'll tell you what his conclusion is. I'm not going to tell you, but I expect you to sit and listen. And I apologize in advance. Some of it may not be exciting stuff like some of the things that you've heard. It may be closer to that testimony like DNA evidence, but I know that you're going to pay attention because this portion of the trial is critical. It's critical to you, and it's critical to Mr. Wilson. Then we're going to have Dr. Mark Mills testify. Dr. Mills is a psychiatrist. He met with Mr. Wilson on a couple of occasions. They didn't get to perform any of the tests that Dr. Mills wanted Mr. Wilson to perform. But he, like Dr. Eisenstein, did a lot of background research, contacted relatives of the defendant, that went over the discovery, went over numerous records from other sources, and he will tell you what his opinion is with regard to Mr. Wilson's mental status and why. Now, we anticipate that the state is going to provide another doctor, Dr. Herkov, who likewise is going to get up there and tell you that he met with Mr. Wilson and he has reviewed documents prepared by my two doctors, and he'll tell you what his conclusion is. And then you're just going to have to decide which one of the doctors you're going to give the greater weight to as far as formulating your opinion. But I want you to be able to sit and write this down when you hear from these doctors, the different terms that they're going to use. We anticipate they're going to use terms like schizophrenic and bipolar, hallucination, adjustment disorders, suicidal, paranoia, delusional. They're going to tell you what those things mean. Then you're going to have to figure out whether or not Mr. Wilson's mental status rises to the level of your consideration to allow him to live. We're going to try and display to you what the thought processes were that were going through Mr. Wilson's head when these events occurred, why they were exacerbated by the consumption of controlled substances. This isn't an excuse for what happened. You've already decided that he killed these two women. We're not trying to excuse his conduct. We're trying to explain to you why somebody who's charming, polite, and cool would have done this. And it was something other than taking drugs that made it beyond Mr. Wilson's control. We believe that after you've, and there's a letter you're going to have an opportunity to read, a letter that was drafted by Mr. Wilson's sister that was provided to both of our expert witnesses, that they took that into consideration. They had a chance to talk to his sister. They had a chance to talk to his mom and dad. They got background information that I don't know that Dr. Herkoff has, but nevertheless they have it. And along with the other documents that they've reviewed, they'll tell you how they took that information into consideration. We believe that after you have entertained our mitigating circumstances, you will go back there, you'll do what you need to, have discussions amongst yourself, you'll figure out what facts are really facts and which recitation and closing argument is a variation of the facts. We believe that you will come back, you will return the only recommendation that you can once you finish that weighing process, and that would be the recommendation of life in prison where Mr. Wilson will die. Thank you.
Say we like to call Ms. Lisa Lansky.